Hi, I am Mrs. Rajkala. Today we are going to learn about the labor laws which are applicable to the catering industries. The aspects of law regulating the hotel and catering industry are generally known as hospitality law. It is the body of law relating to the food service, travel and lodging industries. We all know that hospitality industry is one of the world's fastest growing industry and revenue earner. There is a rapid development of this industry over the last few decades, and it approximately employs 10% of the world labor force. Any hotelier enters into a legal relationship not only with his customers but also with his employees, suppliers, trade unions, travel agents and operators, as well as subcontractors in the line of trade. In turn, this industry is regulated by the government and other professional bodies. Therefore, a hotelier must be aware of the boundaries within which he can operate. In this regard, a sound knowledge of the law as well as fundamental business management skills of the hospitality profession is very essential. The hospitality law usually regulates a number of issues pertaining to hospitality, such as theft or crime committed within the hotel premises, ensuring safety of hotel guests, breach of contract for reservation, health and safety of employees, dismissal of employees, price list and stipulations, restaurant permits, safety and working condition of employees. Once you complete this module, you will be able to identify the basic labor laws governing the hospitality industry. You will be able to identify and explain the labor regulations, understand the laws with respect to safety and security at workplace. For the successful operation of any hospitality industry, it is binding on the owners and managers to fulfill certain obligations. Some of these are unwritten, such as the obligation to satisfy the customers. Others are written down in the form of contracts mutually agreed upon by employers and the employees. Still others are based on the expectation of the people within the establishment and outside of it, which are developed as codes of practice over the years. In considering the legal implication, the employer and the employee have to be aware of the fact that laws keep changing time to time based on the changing patterns and needs of the society. Finally, there are certain legal obligations which need to be fulfilled for safeguarding the health and well-being of people and the establishment. It is this last group which will be dealt in this module, focusing attention on laws and regulation which affect the hospitality industry and therefore need to be complied with. Now, what are these labor laws? Labor laws is the body of laws, administrative rulings and precedents which address the relationship between the employers, employees and labor organizations, and this often deals with the issues of public law. The main goal of labor laws is to bring both employer and the employee on the same level, thereby mitigating the differences between the two ever-warring groups. Now let us see a little bit more on the origin of labor laws. How did this labor laws origin? If you look into the history of labor laws, it clearly shows that all the laws emerged when the employers tried to restrict the power of the workers' organizations and keep labor costs low. The workers began demanding better conditions and the right to organize so as to improve their standard of living. The workers' demand led to increase in the cost for the employers. This led to a chaotic situation which required the intervention of government. In order to put an end, the government enacted many labor laws in the country. The history of labor legislation in India can be traced back to the history of British colonialism. In the beginning, it was difficult to get enough regular Indian workers to run the British establishments, and hence the laws for chartering workers became necessary. The Factories Act was first introduced in 1883 because of the pressure brought on by the British Parliament by the textile moguls of Manchester and Lancashire. Thus, we received the first stipulation of 8 hours of work, the abolition of child labor, the restriction of women in night employment, and the introduction of overtime wages for work beyond 8 hours. India has got various labor laws such as resolution of industrial disputes, working conditions, labor compensation, insurance, child labor, equal remuneration, etc. In many countries, it is employer's duty to provide written particulars of employment to an employee. It is otherwise called as contract of employment. This aims to allow the employee to know concretely what to expect from the company and what is expected out of him in terms of wages, holiday rights, notice in the event of dismissal, job description, and so on. An employee may not, for instance, agree to a contract which allows an employer to dismiss them unfairly. Legislations concerned with employment of people started in India over 130 years ago with the Apprentice Act of 1850, which obligated on part of the employers to safeguard the welfare of the employees while teaching them respective skills. After independence, with the growth of industrialization, came the Fatal Accident Act 1855 to compensate employees' families in case of fatal accident occurring at the workplace. To deal with conduct of employees at work, the Breach of Contract Act came in 1859 and Employees and Workmen Dispute Act in 1860 to settle any grievances arising at work. The trade union movement brought about a general awareness about employees of their right through the employers, and legislations increased to keep pace with the changing requirements of the employers and employees. Labor officers were appointed by Royal Commission to liaise with the employers to ensure that sound recruitment practices were followed by them. These officers were expected to ensure that workers were provided good working conditions, canteen facilities for meals, fair price shops, recreation, medical housing facilities, etc. It was in 1947 with the enactment of Industrial Disputes Act that the welfare officers' role shifted from that of welfare to handling of disputes relating to the conditions of service, salaries, leave, and pension benefits. It was only after 1960 that laws covering all the important aspects of personnel management were promulgated. There are at present more than 110 laws covering employment and working conditions of employees, with amendments appearing from time to time to keep up with the changes in the living and working environment of the people. The primary obligation of every establishment is that it should be registered so that it has the legal sanction to operate as a place of public service. Registration of the establishment may be done by the municipal corporation of the region or controlled by the central government depending upon the location and size of the facility. Let us see some of the primary areas covered by legislation for employees such as working conditions, welfare, health and safety, harmonious working relations and payments. Now let us see one by one in detail. First, let us look into the working conditions. The Shops and Establishments Act 1954 covers the conditions of work which must be provided by all the employers in catering establishments. Working condition refers to the fixation of working hours, regular and timely payment of wages, paid leave, creation of healthy working environment through the provision of basic necessities such as toilets, washing facilities, restrooms, comfort at work, and the establishment of good human relations. The Act requires every employer to specify the hours of work which each employee is expected to put in on every working day. Employer has to ensure that no one is required to work for more than 5 hours at a stretch without at least a half an hour break, or 9 hours on a single day, or 48 hours in any single week. In case it becomes necessary in conditions of emergencies such as staff shortages, strike, etc., for people to work for longer hours, no person should be made to work for more than 54 hours a week. Every employee must have a fixed duration lunch break varying from 45 minutes to 1 hour. The time period fixed must remain operative for a minimum of 3 months before it can be changed. Every employee must have at least 24 continuous hours off in a week with full wages. The period during which wages will be paid every month need to be specified, and payment is expected to be paid promptly every month. The Act also prohibits children from being employed. Any establishment employing people less than 18 years of age would be considered to be violating the laws. Now coming to the welfare measures. The Factories Act 1948 covers the obligation of employers regarding the comfort and welfare facilities of the staff. This act applies to all the establishments employing more than 10 workers and using electrical power in its operations. It also applies to all the premises where 200 or more employees work, even if no electricity is used. It does not apply to premises operated by self-employed persons or their families. The Factories Act expects all the employers to provide minimum safeguards for the safety, health, and welfare of people at work. To fulfill the conditions laid down by the Act, every owner or the manager of an establishment must look after those aspects concerned with the welfare of the employees. The provision of welfare by an employer usually includes washing facilities for the staff along with toilets and restrooms. First aid facilities should be provided, paid annual leave, uniforms to be provided including footwear that is comfortable for work, working hours not exceeding 10.5 hours per day including the rest periods. Provision should also be made for overtime work. Paid annual leave should be given at the rate of 1 month's salary for every year of service for permanent employees. The Employees State Insurance Act 1948 also takes care of provision of benefits to the employees which are financed from contributions of employees, employers, and the state. The Act was designed to help the employees cover their expenses during periods of sickness, maternity, or injury. The benefit is also expected to be paid in the form of a pension to the dependents of worker who may sustain fatal injuries at work. The Act applies to all establishments employing 20 or more persons. Other benefits under the Act include canteen facilities, the provision of canteen facilities and meals at subsidized rates, especially where more than 250 workers are employed. As far as food service establishments are concerned, the provision of meals, either free or at subsidized rate, has become custom and practice even in small establishments with less than 20 workers. This is because the product of catering establishment is food, and the benefit acts as a deterrent to pilferage. Besides, it is an established fact that provision of refreshments at regular intervals during working hours increases the efficiency throughout the day. Next comes housing facility. These may take the form of housing or payment of a portion of the salary dispersed as house rent allowances or HRA for renting of accommodations. Management may also offer loans for building and so on. The third is financial and legal services. These involve offering loan and credit facilities to employees who are in need of money for various reasons. Legal advice may also be given when necessary to maintain the morale of the people. The fourth is purchasing services. Some establishments may set up a scheme for the benefit of employees for purchase of food items in stock at discounted prices. This is beneficial both to the institution and the employees because in catering it is better to sell out the prepared food items at the end of the day than to risk storing them for the next day, especially when cold storage facilities are inadequate. This helps employees to carry home ready-made meals and snacks instead of having to stop and shop on the way home after a full day's work. The last one is recreational activities. The provision of physical and mental diversion at work is becoming increasingly important to people. Even in very small establishments, it has become a practice to provide music through radio or tape. In larger establishments, the concept of providing indoor activities like reading, cards, carom, etc. for employees during breaks is gaining significance. Now let us look into the health and safety measures. The Factories Act also lays down conditions to safeguard the health and safety of people at work. In order to conform to the Act, employers are liable to provide an environment which does not in any way affect adversely the health of any person or injure or disable him in any way. To ensure a healthy environment, it is necessary to guarantee the cleanliness of the establishment and the staff, proper disposal of waste material, proper ventilation to prevent dust and fumes from collecting in the work environment, and to control humidity through the provision of exhaust fans. Lighting should be such that it should not affect the visibility and eyesight of the people at work. Overcrowding should be avoided by proper planning of work areas. Clean drinking water should be provided. Proper washing and toilet facilities are essential. Now, let us look into the procedures suggested for safety of employees at work. There should be periodic maintenance of electrical appliances, proper placement of firefighting equipments and its regular maintenance, establishment of good working habits and safety policy. There should be adequate supply of safe water, immediate and safe disposal of waste, a high level of building and equipment maintenance, comfortable working temperatures, adequate sanitary facilities for staff and customers, at least one toilet for every 12 people. Training should be provided in usage of equipments to eliminate the risk of injury, and eradication of rodents, insects and pests of all kinds. Next, we will see on harmonious working relations. The Industrial Disputes Act 1947 makes provision for good working relations through the establishment of free communications and negotiations between people at work. In case of disputes, it only covers those which are supported by a trade union or a large number of workers. The Act also outlines measures for preventing or settling grievances and disputes, prohibiting strikes and lockouts, and negotiating terms and conditions on behalf of employees and employers. At work, the obligations between the employees and the employers to each other are based on contract, either written or verbal, between them. The Indian Contract Act 1872 deals with the general principles of the law of contract. It ensures realization of reasonable expectations of both parties entering into a legally enforceable agreement at the time of employment. But the Act doesn't spell out the rights and duties which it will enforce, but it provides the structure within which the parties may chalk out their own rights and duties. These the laws will uphold and enforce. The essence of the contract thus involves full and final agreement on the details of the contract in the same sense and at the same time by both the parties, that is, there must be mutual understanding. In addition, the Factories Act 1948 is a piece of social welfare legislation governing working conditions of people in factories in harmonious working relations at work. The Act particularly defines factories to include the establishments which prepare articles of food and service to members of the public. It also classes workers as all the people employed in a kitchen for preparing food for sale and canteen workers supplying the basic and essential amenities to workers who are engaged in manufacture of goods for sale. Now, what are these trade unions? They are basically associations of workers formed for regulation of whether it be among employers or employees or both. These associations are supposed to function so that people can act together to strengthen their bargaining power and negotiate with the employers on progressive or controversial matters. The central government has recently considered a comprehensive law on industrial relations in the form of Industrial Relations Bill with a view to promote peace and harmony at work through good employer-employee relationship. Now coming to the payments. Payments include those made to the employees in lieu of their work done. These may be in the form of wages, bonus, insurance premiums, provident fund and gratuity payments. Sometimes the employers are liable to make cash payments in the form of compensation for injury or loss to the employees at work. The Compensation Act, however, applies only to those establishments which are not covered by the Employees State Insurance Act 1948. The Minimum Wages Act 1948 was an effort to prevent the employers from exploiting the employees in terms of underpaying them. The hospitality industry is particularly prone in this respect, and the employment of cheap labor is still existent in small establishments which are not often covered by legislations. The criteria set out for wage fixation in the Act are: number 1, living wages. These are expected to be linked with the cost of living index and the supply and demand situation of the labor. Number 2 is the ability to pay. The payment of wages is related to the conditions provided by each type of establishment for work and wage and salary agreements between employer and employees made according to the specific job requirements. Number 3 is fixing wages. It depends upon the going rate within the hospitality industry. What various establishments are paying in a particular area is further related to the productivity of the employees and the bargaining power of the recognized trade unions. The minimum wage rate may be fixed for time and piece of work and also for overtime. The fixation must be in relation to the different types of jobs, the age and experience of the employee, the location of the establishment on which depends the availability of the staff and permanence of appointment, and so on. Permanent employees are generally paid a basic salary with the allowance adjusted according to the cost of living index. The minimum wage may be fixed based on the per hour, per day or per month basis, based on whether the employee is a permanent employee or temporary for a few hours a day or part-time for few hours a week. Where wages are not linked to the cost of living index, benefits in the form of subsidized meals or a facility for purchase of food items at concessional rates for the family may be existent. In some establishments, a rate may be fixed which includes the basic rate, concession and benefits. Thus, wages may be paid partly in cash and partly in kind. From the viewpoint of the employees, his wages are as good as the purchasing power that they confer and the security they give him and his family. The wage policy of any family must not only help to fulfill the basic needs of the employee, but also motivate him to work better and reward him for success and achievement. A good wage policy is one that pays fair wages while still maintaining a control over the labor cost, which is one of the highest costs in the hospitality industry. According to the Payment of Bonus Act 1956, employers are required to pay a bonus of 8 1/3% of the basic salary of each employee in establishments where 20 or more persons are employed. This is irrespective of whether or not the establishment has made profit at the end of the accounting year. The Payment of Gratuity Act 1973 was legislated to provide security to employees after retirement and to their families in the event of their death. The Maternity Benefits Act 1961. This is an act to regulate the employment of women in certain establishments for certain period before and after childbirth and to provide for maternity benefit and certain other benefits. Objective of the act is that the Maternity Leave and Benefit Act is to protect the dignity of motherhood by providing the complete and healthy care to the woman and her child when she is not able to perform her duty due to her health conditions. In the modern world, as the participation of women employees is growing in every industry, so the need of the maternity leave and other benefits are becoming increasingly common. Right of maternity benefit. Every pregnant working woman in any establishment are eligible for maternity benefit provided they have served in the establishment for at least 80 days in 12 months before the expected date of delivery. However, if a woman is earning less than rupees 15,000, she may be offered ESI scheme by her employer and she will receive the maternity benefit from ESI scheme. To summarize, hotels, like all real property, are subject to governmental regulations. However, if they fail to comply with such laws and regulations, they may be subjected to significant liabilities, fines or penalties which could increase their expenses and result in lower operating margins. All the managers of food service establishments, however, should concentrate on training all the staffs to comply with the standards laid down. It is also important that every member of the establishment be aware of the legal, financial and other implications of not achieving the standards laid down by the law. Legislation thus covers all possible aspects of health, welfare and safety of people at work.